Thank you, President Randy. It's my pleasure and honor today to introduce our speaker, Justice Pat Dewine. Pat Dewine has been a member of the Ohio Supreme Court since January of 2017. Prior to his election to the Supreme Court, Justice Dewine served for 4 years on the First District Court of Appeals, and prior to that, for 4 years on the Hamilton County Common Pleas Court. Justice Dewine is an adjunct professor at the University of Cincinnati College of Law, where he teaches appellate practice and procedure. In addition, he has taught undergraduate courses at the University of Cincinnati in Ohio Government and Politics and American Courts. Justice Dewine graduated from the University of Michigan Law School in the top 10% of his class with the Order of the Coif Honors. He received his undergraduate education at Miami University, where he earned summa cum laude honors. He was also a member of the varsity track and cross country teams. After law school, he clerked for the Honorable David A. Nelson on the United States Court of Appeals for the Sixth Circuit. Justice Dewine later practiced law for 13 years in Cincinnati with Keating, Muthing, and Kleekamp, where he handled a diverse range of litigation matters, including appellate litigation, mass tort bankruptcies, and constitutional issues. Prior to becoming a judge, Justice Dewine served as a Hamilton County Commissioner and a member of the Cincinnati City Council. He was a founder of the Build Cincinnati Reform Group that successfully passed a charter amendment to allow Cincinnati voters to directly elect the mayor. We're very pleased to have him with us today. Please give a warm Rotary welcome to Justice Pat Dewine.
Great. Thank you all very much for having me today. And I was glad to hear about that you guys are working on the Imagination Library. My mother, who's been very involved in that, will be pleased to hear when I tell her that I was speaking to the Rotary in Kent and they were talking about the Imagination Library. So let me, I'm going to share my screen here. Let's see. Okay. Well, let me hold on one second. Let me make sure I get the right thing opened and then I'll try this again. Okay, let's try this. Here we go. All right, I'm going to give a little presentation on what we do at the Ohio Supreme Court. I'm going to kind of walk you through a case kind of from beginning to end to kind of show what it is we do every day and kind of use that to illustrate what the court does. So I'm happy to answer questions while we're going or afterwards. So first question I get from a lot of people is, how do you get on the Ohio Supreme Court? People ask, are you appointed? Do you have a lifetime appointment? And then the answer is, I wish. Now we're elected. Unlike federal judges, we're elected by you. The reason for that goes back to Ohio's Constitution of 1851, which is our current Constitution we have today. And believe it or not, when Ohio was enacting a new constitution, one of the big issues was the selection of judges. Under the old Constitution, the legislature had selected the judges, and people thought that judges were beholden to the legislature. So some people said, let's have a federal model, let's have the governor select, but others said, we'll have the same problem. So ultimately, the view that carried the day was that we should be accountable only to you. The only way to make judges truly independent was to have them answerable, not to another branch of government, but to the voters directly. So we're elected by you. If you don't like us, you can throw us out of office. We run for a term of years every 6 years. So why should you care about the Ohio Supreme Court? I mean, it's obvious, I think, why you care about your mayor or governor or state legislature, but why do you care about the court? Well, let's talk about some reasons. One is 90% of cases are going to be heard in state courts. You hear about federal courts all the time, but the real workhorses are the state courts. That's where the cases that affect your daily lives are going to be heard. Things like an adoption, a divorce, if you die, the state goes through probate, if you have a contract action, if you're a victim of crime, all those things are going to happen in state courts. And in state courts, in Ohio, the Ohio Supreme Court is going to set the precedent that applies in every other court. I think the most important thing we do is we protect your individual rights and freedoms. You're guaranteed certain rights under the United States Constitution and also the Ohio Constitution: right to free speech, right to freedom of religion, the Second Amendment, right to bear arms. So those rights only have meaning when you have a court system that can enforce them and can step in when another branch of government is infringing upon those rights. So we have what I think is a really awesome power, which is the ability to say that a law passed by the General Assembly or something that the executive branch did is unconstitutional, can't be enforced. Why else? Jobs in the economy. You don't think about courts as job creators, but the reality is that places without functioning legal systems are places people don't want to invest and do business. Having a clear set of rules allows people to do things in the state, and that helps attract business here, helps keep people. Public safety goes without speaking, but our criminal laws are going to be enforced in our court system. So if you care about public safety, you ought to care about what happens in court. And finally, even when you don't see the court system, having a backdrop of legal rules that can be enforced in court allows much of our modern life to go on. Think about something that we were talking about, buying a house earlier. Well, what happens when you buy a house? You write a contract, someone accepts the contract, you set a closing date, bank loans you money. Well, none of those things happen without a court system that works. So the reason that someone is willing to write that contract is because they know that if the other side doesn't fulfill it, that they can go to court and enforce it. The bank's willing to loan you money because if you don't pay it back, they can foreclose on your house. So even when you don't see the court system, having that court system there allows so much that we don't think about courts being involved in to happen. So I promised you I'm going to kind of walk you through a case, how it gets to the Ohio Supreme Court and what we do with it. I'm going to tell you a story. This is a real case, the case we had decided at the end of last year. It's about two flower shops, not all that far from you, in Wooster, Ohio. One was called Wooster Floral and Gifts. One was called Green Thumb Floral. They were competitors. The owner of Wooster Floral got tired of selling flowers. She said she was going out of business. She set about closing down her flower shop. In the process, she had a domain name, woosterfloral.com. She didn't renew that. She let it lapse. But while all this was going on, one of her employees said, you know what? I would love to be in the flower business. So they ended up working on a deal where the employee took over this flower shop, opened it up under a new, slightly different name, but pretty much kept Wooster Floral as it was. Well, after that transition period, say someone wanted to go on the internet and type in woosterfloral.com. Here's what they would see. So the owner of Green Thumb bought that domain name that the old owner let lapse, and she used it to redirect people to greenthumb.com. Not all that uncommon. We all are kind of used to going on the internet, think we're going one place, you end up somewhere else. But depending on how you look at it, the owner of Green Thumb probably thought this was a great business strategy. The owner of Wooster Floral, though, thought it was a dirty trick. So what did she do? Well, the first thing she did was she confronted her. I think she actually sent her husband to talk to the owner of Green Thumb Floral and demanded that Green Thumb stop using woosterfloral.com. Well, the owner of Green Thumb said, no, I paid for this fair and square. Too bad. But if you want, I will sell you the domain name. For $2,500, it can be yours. The owner of Wooster Floral didn't think that was very fair. So what do you think she did? Well, she filed a lawsuit. So she went to Wayne County Court of Common Pleas. She filed a lawsuit. She asked the court to issue an injunction to order Green Thumb to stop using that name. She said she was entitled to that injunction because Green Thumb was violating something called the Ohio Deceptive Trade Practices Act. That's a law passed by the Ohio legislature that says it's illegal to use advertising that, quote, creates a likelihood of confusion or misunderstanding as to the source of goods or services. So lawsuits teed up. The trial court hears the lawsuit, listens to, it's a trial, so we have witnesses, we have evidence. In this case, no one asked for a jury, so it's just a judge heard the case. Judge heard the evidence, found no violation of the law. So what's next? Well, in Ohio, if you lose in the trial court, you have an automatic right to appeal. Any loser in a case can appeal simply by filing a notice of appeal, paying their filing fee, and they're going to go to the Court of Appeals. Here, it's the 9th District Court of Appeals. Actually, I think it's the same Court of Appeals that you would be in Kent. And we have 12 courts of appeals in Ohio, depending on where you're located. So in the Court of Appeals, it's not one judge, it's 3 judges who are going to hear the case. The idea is that on appeal, we should have more opportunity for dispassionate reflection. So we're going to have 3 judges, and there's no new evidence presented. You don't retry the case. You simply argue about why the judge below made a mistake. So each attorney will argue generally for 15 minutes. Court will consider the arguments, they'll consider briefs, and they'll make a decision. So in this case, the court heard arguments and ultimately decided that there was no violation of the law. They voted 2-1 to affirm the trial court. So what's next? Well, here's where the Ohio Supreme Court comes in. The owner of Wooster Floral, she wasn't done yet. She wanted to keep fighting. So she filed an appeal to the Ohio Supreme Court. Well, it's different appealing to the Ohio Supreme Court because you don't have an automatic right to be heard. You have to write what we call a jurisdictional memorandum and convince the court why your case is so important that we ought to hear it. 2019, we had 1,100 jurisdictional appeals filed. We only accepted 43. So your odds are fairly tough getting in the court. It's not enough to say that the court below got something wrong. You have to show why the case is one of great public importance. So why deciding this case will matter throughout the state. Maybe there's 2 different courts of appeals in different parts of the state who've looked at the same issue and decided differently. But we don't like that. We want the law to be consistent across the state. So that might be a case that we accept. In this case, 4 members of the court thought it was important enough to accept. So 4 out of 7, a majority voted to take it. So it came in. So, and typically what I'll do is I'll get about a stack of about 50 of these briefs every week, every 2 weeks. And so I'll go through them all. I'll read them all. Some of them I read very quickly because I can tell right up front that I'm not interested in this case. Other ones I'll spend a lot of time with. I think this might be something worth taking. So we'll do that. We'll submit our votes, and then those votes we tallied, and whoever gets 4 or more votes comes in. So once the case is in court, what do we do? First thing is there's briefing. So people think of me as a Supreme Court justice as sitting behind the bench. The reality is I'm only behind the bench about 5 days a month on average. Most of the time, I'm actually sitting at a desk, reading and writing. And so a lot of this is these briefs and these cases that we've accepted. So I'll read all the briefs. There'll be 3 briefs. The party who lost will write a brief, then the other side will write a response, and then the losing party will get the last word. I'll read the briefs. After I read them, my law clerk will also read them. I have 3 law clerks. They'll write me a memo about the case. I'll go back and forth, discuss the case. Generally, by the time oral argument rolls around, I'll have a pretty good idea of how I want to decide. So next step is oral argument. We're generally Tuesday and Wednesday, a couple of times a month. We'll hear 4 or 5 cases in a day. It looks like this. Now, typically what would happen, she'd get about a minute into her speech and we'd start asking her questions. Oral argument really isn't a time when you get to stand up and give a speech. It's really more of a time that you respond to questions from the court. We're a pretty hot bench, so you're going to get a lot of questions. And really, what I tell people is people who do well in oral argument come in with 3 or 4 points they want to make, and they're able to kind of transition from whatever the questions are to those points. So we might ask hypothetical questions. We might say, well, here's the rule that you want us to write. How would that apply in a different case? We're kind of trying to test out the rules and see how they're going to apply beyond the facts in front of us. Oral argument, each side gets 15 minutes. You think about it, it's not a lot. You could have a jury trial go on for 3-4 weeks. Time you get to oral argument in front of the court, you've got 15 minutes generally. That's what oral arguments usually looks like. Unfortunately, for the last year, it's looked more like this.
Our second case, 2009.
So like you, we've been doing our proceedings by Zoom. I hope that we're almost done with that. I don't think we've gotten less out of it. It's actually really not that hard. You just have attorneys arguing. I think it's much harder for our trial courts who are dealing with witnesses and juries and that kind of thing. But I certainly miss being in the courtroom, and I'm anxious to be back there as soon as we can. So what happens after oral arguments? Well, we have to decide who's going to, we have to decide how, at least preliminarily, how the case is going to come out and who gets to write the decision or who has to write the decision. So we huddle. We go back to our conference room. You'll see on the left side of your screen. The procedure we use is we'll have 4 or 5 cases decide a day. The chief will call a case. She'll say what she thinks, and then we'll go down in order of seniority, and everyone will have a chance to talk. The great thing about this is that the first time through, no one can interrupt anyone, which seems easy enough, but actually in practice, at least for me, it's often hard because you want to jump in and help someone get back on track or ask them a question or argue your point. But it's a pretty ironclad rule that no one can interrupt, and it's strictly enforced. I grew up in a family of 8 kids. It probably would have been a rule that would have worked well at our dinner table. So we'll do that. Then after we've discussed it,
Oh God,
gone
I'm
through
so
once.
sorry. That explains why.
After we've gone through once, then we'll kind of
Oh,
free for all.
wow. Oh my gosh.
Everyone.
Did you guys, like, what kind of symptoms did you have? Was everybody out of the hospital and stuff?
So once we've gone through
Wow.
once, we'll kind of have a free for all, and then when that's done, we'll take a preliminary vote. So we vote from the bottom up, the most junior votes
Okay.
first,
Yeah.
on up to the senior justice. After we voted, then we have to decide who writes it. So I don't know if any of you ever seen a bottle like this. It's a leather bottle, but it came out of a pool hall, I think in Cleveland somewhere. And that's what I tell people is, in the United States Supreme Court, the Chief Justice assigns the opinion, as you may know, to someone in the majority. In the Ohio Supreme Court, we are much more sophisticated. We play a dice game. So we use this bottle. There's 7 numbers. I happen to be number 2 this year. Numbers go in. Whoever's the majority, one of the justices rolls the bottle, shakes it, rolls it, and whoever's pill, as they call them, comes out. That justice is assigned to write the majority opinion. So why do we write opinions? Why isn't it like Law and Order sometimes, where the appeals court just kind of goes back and consults and comes out and announces their decision from the bench? Well, a couple of reasons. One is I mentioned that other courts in Ohio have to follow our precedent. So they need to understand not just what we decided, but how we applied the law to the facts of our case so they can apply them to different facts. So that's one reason. The other reason really goes to kind of legitimacy of our court system. What Alexander Hamilton said when he wrote the Federalist Papers, wrote from the Federalist Papers, what he said about the judiciary was that the judiciary was the least dangerous branch of government. By that, what he said was that unlike the executive branch, the president, the judiciary didn't have the power of the sword. We can't call it the army to enforce our will. Unlike the legislative branch, we don't have the power of the purse. We can't tax or spend money to accomplish what we want. All we have is judgment. All we have is the confidence people place in us. And so part of instilling that confidence is writing written opinions so people can understand why we decided what we decided. When I write an opinion, I try to write it in plain English. I want something that's written that someone can pick up and understand, not be a lawyer. And I think about the losing party in the case. I want that person to be able to pick up the opinion. They're not going to be happy, but to at least see that what we decided was based on law and precedent and not just on the whims of the judges, part of the rule of law. In this case, I kind of skipped over it, by the way, but we voted to affirm the trial courts. We found that this was not a violation of the law. What the statute says is that there has to be a likelihood of confusion as to the source of goods or services. When you go on this, when you type in woosterfloral.com, it's immediately clear that you're on Green Thumb's website. So there's no deception there, at least by the time you order the goods and services. So we found it was not a violation of the law. One judge disagreed. Justice French would have sent it back for more proceedings in the lower courts. So she wrote a dissent. And typically the way it works is that we have that initial vote. Then we leave conference, and I was charged with writing the opinion in this case. So I'm back to my chambers, and I don't know what took us, a month, 3 weeks, whatever. We wrote the opinion in this case. Then we circulate to the other justices, and so anyone could weigh in that wanted to, could write a dissent or a concurrence. So Justice French wrote a dissent, and then kind of a back and forth process. She said some things about my opinion. I responded to what she said, kind of back and forth till we were done writing. Then it comes back and we vote again. And the second vote is actually on the opinion itself. And so sometimes the dissent will get more votes than the majority, and the justice who wrote the dissent will have to rewrite it and make it into a majority opinion, or we'll get to rewrite it. And the majority will have to do likewise. But in this case, my majority opinions stayed a majority opinion. So it was ultimately released to the public. So why do we have dissents? Why don't all judges see things the same way? Well, I think there's a number of reasons. One is, at least in our court, we're only accepting the hard cases. I mentioned we only take about 5% of the cases we're asked to. So there are cases where there's a room for differences of opinion. But second, I think it goes to different judicial philosophies. I see the role of a judge as someone I'm what I call a strict constructionist. I'll take the statute and I apply the plain language of what that statute says. I don't really get into, well, what would I like the law to be? What should the law be? I think our role as a court is simply to apply the law to legislatures to write the law. Other people may take a more expansive view and say, okay, well, what was really intended here? What's the best result? So those kind of different philosophies lead to different results sometimes. Last question, people ask me, and usually if I'm doing this live, I ask the audience, and I get about 50-50, whether people think Wooster Floral can appeal or not. Some people say you can appeal the federal courts. Some people say they can appeal the United States Supreme Court. Other people say they cannot appeal, and that's the right answer. This is a question of state law. I mentioned it was a statute enacted by the General Assembly. When it comes to questions of state law, we have the last word. We cannot be overruled by the United States Supreme Court. if this had been a question, if this case had involved some kind of federal law, maybe it was a criminal case, and there was a burglary, and the police had gone into the defendant's home and found the stolen items. Well, the defendant might raise a claim that there was an illegal search and seizure that violated the Fourth Amendment of the United States Constitution. But that would have a federal issue in it, the United States Constitution. So then after we got done, you could ask the United States Supreme Court to hear the case. They wouldn't have to, but just like us, the review is discretionary. So if you got enough votes, it could come into the U.S. Supreme Court. Let me just stop there. Here's some contact info, and I'm happy to. I'd be happy to take any questions from anyone about this or anything else you would like to talk about.
Just a comment. David Dix's sister, Chris Dix Frost, was the clerk for the Ohio Supreme Court.
Oh, is that right?
Her father also was a member of our club, but that was about 10 years ago. She was the clerk.
I've been on the court for about 5 years, so that was before my time. But that's excellent. That's a very big job, being the clerk of the United States Supreme, or the highest Supreme Court.
Justice Dewine, I have a question. It's Randy Smith. Are the actual participants in the lawsuit ever present at the Supreme Court level, or is it just the lawyers?
They certainly are welcome to come watch, and sometimes they do, but they generally are not recognized or sitting at the council table. I mean, it's really, when it gets to us, it's an arguing about the law. Sometimes we'll have an attorney, and this is probably someone who's done a lot of a trial attorney, and they might say, might be a case where, you have sympathetic plaintiffs or victims, and they might say, here's my clients are sitting in the first row. I always tell people that that's probably not a good idea. That I think that when you get to the appellate level, we expect it really to be about the law. So, those kind of naked appeals of sympathy, work well in like maybe a jury trial. They don't really work well in our court. So, certainly, everything is open to the participants in the case, but they really don't play a part. It's really the lawyers, unless, of course, someone has the right to appear pro se. So sometimes someone will represent themselves. That really doesn't happen very often in front of us, because if it was a criminal case, we would appoint an attorney for someone if we accepted the case. It's not required by law. There's not a right to an attorney in the Supreme Court like there is in the trial court, but we would to make sure the case is argued as well as it could be, the person with law representative, we would go ahead and appoint counsel. So we don't have too many pro se people, except one thing we do is we do attorney discipline cases. So we get all the attorney, we get any attorney who's being disciplined in Ohio, and sometimes they show up and represent themselves, which really isn't a good idea either. But people often do that, even
Okay, thanks. David, do you have a question?
Yes, I was not clear. You say that you have a discussion to decide what the opinion is going to be, and then it's kind of put the numbers in a bottle, and whatever comes out, that's how it's assigned. Who's going to write it?
That's right. So we take whoever's in the majority.
Excuse me. Go ahead.
We take whoever's in the majority goes in the bottom. Now it's a little more complicated than that, because we even out who's, we try to make sure everyone gets the same number of opinions to write. So if you've got an opinion, you don't go back in the bottle until everyone else gets a case. But yeah, it's a random process.
But you have to agree with it. You write the opinion. Yeah.
Only people in the majority would go in the bottle. So if you disagree, you wouldn't go in the bottle.
Thank you.
Justice DeWine, I have a quick question for you. Actually, first a statement. Would it be fair to say that Worcester Floral should have just paid the $2,500 and avoided all that hassle and all that financial mess? But that's just a silly statement. The second question is how, since you are an elected official, how do you run a campaign when you're trying to be, impartial? You're trying to be just a rule of law and not a political direction.
Right. So they take the first question or comment first. Yes, they would have been a lot better off paying the $2,500. I'm almost certain. I don't, when you sit where I do, you never know exactly what motivates people and some of the kind of settlement negotiations, all those things. So I don't have any insight into that except what's part of the record. But in generally, I'm not talking about this case specifically, but generally, people aren't always the most rational, at least in dollar and cents terms, in the litigation process. What you learn being a judge is that there are a lot of emotions that go into things, and you can. When I was a trial judge, I used to try to explain to people, okay, you're going to spend this much money on litigation. You're going to spend this much money. You'd both be better off if you settled for some number in the middle. And it was really hard to convince people of that, at least at the beginning of the case, until they'd spent a lot of money, because people, they get very vested and, people have strong emotions. So, but I don't know exactly, what went on here. As far as how we run for office, that's a little bit of a challenge. We have ethical rules that talk about what we can talk about. So I can't say to you, I would decide a certain case this way. Vote for me because I will decide this case on the whatever issue a certain way. So what we do is we talk about our qualifications, our experience, and we talk about our judicial philosophy. Those are generally kind of the things that are fair game on the campaign trail. So it's before I was a judge, I was kind of on the other side of the political. I was a city council person in Cincinnati, and then I was a county commissioner in Hamilton County, where Cincinnati is. And so it was a very kind of, and those jobs are great. I mean, as far as campaign, they're easy, right? You can say, I'm going to raise, I'm going to cut taxes, or I'm going to build a new stadium, or you can talk about, very specific things. It's much harder as getting used to running for judge and having to talk about being much more circumspect about what you talk about.
Thank you.
Sure.
Justice DeWine, I have a question. What happens, and this question may even be wrong from the beginning, but what happens if the U.S. Supreme Court sends down a ruling that is nuanced as it can be, but it conflicts with a law that you have heard on the state level? What happens then between those two versions and views of the law?
So when it comes to federal law, if it's a question of federal law, so if it's a question of the United States Constitution or something passed by Congress, under the supremacy clause, federal law is supreme. So we are bound to follow decisions of the United States Supreme Court when it comes to federal law. So, I might be deciding, this happens quite often, a case that involves the First Amendment, free speech rights. I may think the federal precedent is wrong on the First Amendment, but I'm bound by the oath I took to follow what the United States Supreme Court has said. Now, sometimes it's not always completely clear how that precedent applies to the facts in front of you. So you have some flexibility based upon, different facts. But ultimately, my oath is, when it comes to federal law, is to try to apply the federal case law as best I can. I mean, I really like it, having cases that raise questions under the Ohio Constitution, because those are fun in the sense that we're completely we're not bound by any other court when it comes to those questions. But when it comes to the
Thank you.
US Constitution. We are.
Well, thank you, Justice DeWine. Excellent program. And it's a custom in our club that we have one of our members respond to our speakers. And
Okay.
today that's going to be our retired municipal court judge, Bill Nome. So, Bill.
Oh, wow. That's awesome.
Thank you. Justice DeWine, thanks for coming out today. As a municipal court judge, I found a lot of people really didn't understand what judges did, and what they knew about judges was what they saw in Perry Mason and Matlock and things like that. And I want to thank you for taking us through the Supreme Court step by step here. And a lot of people, I don't think, realize how all-encompassing Supreme Court jurisdiction is. You can hear cases like you said today with the Ohio Deceptive Trade Practices Act. You get probate, you get domestic relations, you get criminals, you get all the death penalty cases. You get a lot of mixed bag up there. And to get behind things are really worked out is interesting. And I'm kind of glad to see the bottle with the numbers up there. I don't know if they still do it here, but in Portage County, when you filed in common pleas, they had a bottle with 2 numbers in there, and you either got common pleas judge 1 or 2, depending on what came out first, to make sure that there was even division of the cases. Also, it's appreciated that you write opinions and you put things in there in plain language. It's a whole lot easier for lawyers trying to explain to their clients what they should do and what they shouldn't do if they can quote from a Supreme Court case and say, this is what the law is, and it's not me telling you, it's a Supreme Court telling you. Sometimes that makes it a little more reasonable in dealing with, do you try it, do you settle it, or do you do something else? And I think the ideas that you've raised about having the courts enforce the rights and using their powers to keep the rules and keep society in line is important, because you can have the finest words written in a document, but if they're not enforced, they're pretty meaningless at that point. And we appreciate you doing that. So thanks again for coming and spending the time with us today and giving us a little bit of a view of what happens behind the scenes at the Supreme Court. Thank you, Justice DeWine.
Thank you. Thank you. Thank you all very much.
All right. Thanks again. And we are officially ended.